computer system and the software are approved by the judiciary and certified as an official recording system for the courts, all levels of the judiciary will be able to rely on those records. And it should be easy, like we propose that in the Constitutional Court you can write a letter and then the others can follow. But we must also be mindful of the fact that even though the procedural aspect might differ, there would be certain consideration that if you are from magistrate and you make an appeal there, what kind of matters are being dealt at that level? Same would apply to the High Court and the Supreme Court of Appeal. So the type and nature, the seriousness, complexity of the matter will also play a role. But in my presentation, I said it would benefit the country if all these procedures are streamlined so that access to justice should be made easier and less cost-effective.
Very much, JP. Thank you, CJ.
Thank you, Chief Justice. Good afternoon, JP.
Good afternoon, Commissioner.
I think you do know that this position will be a second in command if the President decides to choose you. And my question relates to the attacks on the judiciary. I mean, a lot of people are complaining that the Constitution is not working for them, and the judges are biased. What do you think you could do, actually, as a DJP, to make sure that people understand the judgments and have confidence in our Constitution?
Yes. Thank you, Commissioner Lepu. The answer I would give will build on my presentation of the translation of all court judgments into official languages. And then the communication department of the judiciary should be strengthened and capacitated so that it can deal with the complaints that are made against the judiciary. I mentioned that as the judiciary, soon after our independence, we've got to sit down and think of roadshows where we go to communities and conscientize them of their rights, because most of the time it's lack of information or misinformation. And parties that are dissatisfied are the ones at times that are causing this problem of misinforming people. But I think we owe it to the South African people to educate them about the Constitution, to show that there's nothing, I would say, with the Constitution. The only problem is how is it implemented by the three arms of the state, because they have to play a role in implementing it, and show them of their rights and what they need to do if there's a problem, and make it easier for them to bring up their complaints if there are any. So that department will obviate the problem of the judges or the Chief Justice being named and then she has to respond, which I don't think it will be an advisable thing to do personally. But have that designated department to deal with that. We have made some progress in that. The department is there, the unit is there, is being capacitated from time to time, and we do have a judge that is responsible for that, and that will be able to address some of the problems. I hope I have covered the Commissioner's concern. Thank you.
Okay, thank you, Chief
Could I
Justice.
follow up on this, Chief Justice? Mr. JP, I mean, firstly, I'm not sure about this translation of all judgments and then
Yes.
Visits by all of the judges to every part of this country. I mean, the minister is telling us there's no money even to pay for new positions. Now, we must now find money, well, the government must find money for a project of translating judgments, and then it must also find money to transport judges around and having workshops with communities, et cetera, et cetera. So anyway, I'm just not sure if you've thought seriously about that proposal in the light of the constraints that the judiciary is currently facing and the priorities it should be having to deliver justice. And I'm not even sure what the object of these visits are going to be. But that's not why I asked to make a follow-up. I wanted to make a follow-up on a substantive issue. The question by Commissioner Matolo-Dlepo is a very crucial one, which is that we have an apparently progressive constitution, but we have the most unequal society in the world by the Gini coefficient according to the studies of the World Bank in 2018 and in 2021. Now, the function of the judiciary is to interpret the constitution. That is the primary function, and to interpret the law and where appropriate to develop the law. But their job is to interpret the constitution. You've said that there is nothing wrong with the constitution. That's fine. Even if there was something wrong, there's nothing we can do. We must live with the constitution we have. But I want to question your premise that there's also nothing wrong with the interpretation of the constitution. Last week, 2 weeks ago, the professor from Stellenbosch, Sandra Liebenberg, gave a speech at the 30th anniversary of the Constitution, in which she questioned whether or not the Grootboom standard is still an appropriate response to the socio-economic crisis that South Africa faces. This is a 25-year-old standard. What is your view on whether the Grootboom standard is still relevant to meet the crisis of inequality that South Africa faces?
Yes. I don't know if I should deal with the initial comment. My answer to that is quite short. I said, once we attain our institutional independence, we could pay attention to ensuring that as the judiciary, we conscientize people of their rights. At the moment, it's not within our own priorities. That will be for the executive to do. But that one is on, what I said was on a long-term basis. I agree, the interpretation of the Constitution is the one that might create problems, and at times it does create problems. The Grootboom standard, I would say it remains relevant provided that it is being developed. We need to allow the executive to make sufficient provision to realize those socioeconomic rights. It's quite difficult because now that will depend on the executive self. But as we interpret the Constitution, we should nudge the executive towards realizing and implementing those rights.
I don't think anyone disagrees with that. I mean, the Grootboom standard essentially...
Sorry, I missed.
I'm saying I don't think anyone disagrees with that, but I'm questioning the content of the Grootboom standard, which is based on this idea of reasonableness.
Yes.
That what the court does is, through judicial review, to assess the reasonableness of the measures taken by the legislature to fulfill the rights in Section 26 and Section 27. Now, the critique specifically is that that standard is inadequate because it's inexact. And the Constitutional Court had rejected in 2000 the minimum core. But it needs to move beyond reasonableness and to give something tangible. And what is the correct way of doing that? And that's the theoretical discussion that Professor Liebenberg was putting forward.
Yes.
Using examples like Daniels versus Scribante, saying, for instance, the content of the right to housing includes habitability of the dwelling.
Yes.
And then a more recent case, delivered by the Constitutional Court says the content of the right to housing includes proximity to places of work or to economic opportunities, right? So which means one is moving beyond reasonableness.
Yes.
Because it's an empty standard that does not concretely realize the object behind Section 26 and Section 27. Now, you are going to come in as an intellectual leader of the court, in fact, the second most important office in the country. So I want to understand your theoretical exposition to the inadequacies of the Grootboom standard.
Yes. As I say, Commissioner Mukatobi, we need to develop that standard further. And I appreciate the steps that have been taken up to date to develop it and to make it more realizable. And one will have to think of a creative way of ensuring that sufficient resources are employed to enforce that standard. I can't just think of a particular example now, but as I say, what is provided should be something that is acceptable to the communities. It should be something that will benefit the community. It should not just be a hollow or a shell that is being provided and say that this is what we can afford, this is what is reasonable. I would suggest that we'll have to do more to ensure that it meets the modern and current standards.
But do you have any specific ideas around the development of the Grootboom standard on a normative basis? This is about how to theorize the socioeconomic rights in section. This is the biggest bulk of the work you have to do as a judge of the Constitutional Court, is to tell us the meaning of Section 26 and Section 27. So how do you think the standard can be taken forward, if at all? I mean, no one questions what you are saying about the community benefiting from the Constitution, but your job is primarily to interpret the Constitution using a theoretical lens of some sort, and you've got a conservative standard that says no minimum core, and then you've got the progressive realization standard that says reasonableness. But is there anything missing from this interpretation? But I think you've probably said as much as you could.
Well,
Commissioner Shabangumdawi, I'm sorry, did I cut you short?
no, you did not, Chief Justice.
All right.
Thank you, CJ. Good afternoon, JP.
Yes, Commissioner.
JP, you will agree with me that we still have not reached a full
If you could
transformation.
speak closer to the mic, please.
Can you hear me now?
I do, yes.
Okay, thank you. I was saying you will agree with me that we still haven't reached a full transformation of judiciary, in particular in gender.
In gender,
Yes.
Okay.
In assisting to achieve full transformation, what contributions have you made? And going forward, what plans do you have to achieve transformation of judiciary in gender?
yes. To achieve gender transformation, it shouldn't start at the courts. I believe that it will start with the education from the universities. We were quite aware that in most universities, women outnumber men, but we do not know what happens to them after completing their studies. So it will be important that it be made easier for them to join the profession. And once they are in the profession, they receive training that will prepare them to be able to move forward in building up a pool from which judges can be appointed to continue with the project of transformation. They must be given opportunities through the briefing patterns by the attorneys, business, government, and other institutions that have the capacity to brief them. They should be given good opportunities to act in the courts so that it should be easy for them to settle. The conditions should be made easier for them to be able to survive, if I may use that word, because in addition to doing judicial work, they would have other responsibilities that they have to cater. So there has to be reasonable accommodation to ensure that these do not impede their progression into the profession. Leadership positions, they should also be appointed to those positions. We are already in a good start, and then we should keep the momentum. Thank you, Commissioner.
Thank you, JP. I just wanted to hear your contribution towards that. I hear you're explaining what is it that is supposed to be done, but your contribution as a judge president of the Northern Cape High Court, any contribution that you have made to make sure that transformation of jury, in particular to women, do you have plans for that?
Yes, I have already started. I have been giving women opportunities and to act. And if you look, we have appointed recently a woman who has joined our ranks. Being a small division, we've got 3 males and 4 women on our bench. So I will continue from time to time, request the minister to appoint women, and we are giving them those opportunities. And where there's a need to have discussions with them, we find out, because I've had meetings with the bar and say, it looks like women do not stay as members of that bar. They've had their challenges, and I asked upon the leadership there to make sure that they make it possible and conditions conducive for women to be part of that. And that is from where the pool from which we can get women onto the bench. We have reached our final quota, and wherever there are permanent appointments, like it has happened in the past, where we had many women trained in the Northern Cape, they were able to take up positions at other divisions. So that program has been working, it continues to remain part of the plan. Thank you.
JP. Thanks, CJ.
Commissioner Moimang?
Thank you, CJ. Good afternoon, Judge President Tlaletsi.
Good afternoon, Commissioner Huima.
Just one question from my side, which relates to the access to justice, the same that I raised with JP Mlambo. The court system, which is currently in existence, largely reflects the pre-democratic apartheid system. And this, in a sense, means that the legacy of colonialism and apartheid continues to plague South Africa with spatial injustice, and which impede on access to justice. In your vision, you did make reference to the challenges that either the accused or witnesses are facing when they must travel from or further to Uppington. Now, I want to get your views or your contribution to the recommendation by Deputy Justice Mosenege's Committee on Rationalization. The proposal for the Northern Cape is that we should retain the Northern Cape Division of High Court in Kimberley, and that a new local seat should be established in Uppington. So I want to get your views or your contribution to this recommendation to the Ministers' Committee. Whether do you Are you of the view that this is an ideal situation? Or is this a desirable situation given the constraints around the resources? What will be your ideal situation? Will your ideal situation be to have this local seats in 5 major towns of Northern Cape or not? Thank you.
Yes. Thank you, Commissioner Mimang. That recommendation came as a result of my contribution when I made a presentation to the Rationalization Committee that we need that local division in Uppington to cater for now to cater for areas like Springbok and up to Port Noloth. But this has been a moving target. Years and years back, we were told by the Department of Justice then that they have agreed with JP Khomu then that division be established. However, they kept on saying, we have identified the site, and then the site might not be suitable. We will upgrade the Uppington Magistrates Court. But only to discover, after I had taken over, that there was nothing on paper except for some few letters which were written. There was hardly a project that was even registered to start working on that project. We started pushing and promises were made, unfortunately. I support the establishment of the local division there, and that local division can spread towards other far-flung areas like Port Noloth and even Springbok, because having everybody to come to, from those areas to come to Uppington will only remove the distance between Uppington and Kimberley. But there was still a long road to travel between those towns. I support it, and I wish it could be one of those things that could be sped up and not wait until the entire rationalization report is being implemented. It could be having its own other challenges. But if this one can be given priority, I would appreciate that. And then we can agree on the number of judges that we would need for that. Thank you, Commissioner.
Thank you, JP. Tlaletsi. Thank you, CJ.
Commissioner Mangena.
Thank you, CJ. Good afternoon, JP Tlaletsi.
Oh, good afternoon, Commissioner.
In your opening, when you shared the vision, you said that we must not drop standards because our jurisprudence is the envy of many other countries. Did I capture you correctly?
You definitely did.
Yes. And with this statement, I would want to assume that you share the view that we've got the best constitution in the world, acclaimed constitution.
I don't know, should it be a dialogue or what?
No,
Through you, Chief Justice.
No, don't answer.
Oh, okay.
But with that said, do you think that the people of South Africa share the same view that the Constitution had been adequately used to advance social and economic inclusivity as envisaged by the Constitution?
Yeah. Commissioner Mangene, you make it difficult for me if you say the people of South Africa. I mean, you've got different classes of people in South Africa. There are those who will tell you that it's working. Maybe it is the connected, it is those who are rich, or those who have won cases. There are those that will say it's not working, the Constitution. And whether it is actually the Constitution that is the one that is questioned in some of the remarks that are being made. is something that one should carefully consider. Because everything now, if it happens, even if it says another arm of state, they will tell you that, no, you see this constitution. Some say we want corporal punishment, we have lost control of our children. Is this constitution? So it's difficult to say the people of South Africa has lost faith in the constitution. It depends from which direction do you approach it. The constitution is there, it's working. It may not reach everybody as one would have expected and would love it to do so. But it's our wish that it should benefit everybody. And it's important for the state to put up resources to make sure that all these aspirations of the constitution, the provisions, benefits the public. I'm not sure whether I've managed to.
No, you did.
Oh, thank you.
My second and last question
Well,
relates to the question.
CJ, just a follow-up on that one.
Yes.
JP,
Yes,
in your own opinion, not a generalized view, has this constitution that is celebrated all over the world achieved that which we went into exile for? Prison, people got killed? Or it is just praise for just being praised, but has not achieved what its original intention? Let's take, for instance, the land question. Let's take, for instance, the economic equalities in South Africa. Let's take, for instance, gender equalities. You've taken on that matter before. Has this constitution achieved all of those things, in your opinion, that we wished for, especially as the oppressed nations? Because it can only be or be celebrated as a good constitution if the oppressor stands to benefit out of it. Thanks.
Thank you, Commissioner.
Not the oppressor, the oppressed.
Yes, I was, okay, now I understand you, Commissioner Malema. Surely it's a work in progress. We wish, all of us, that the society that we aspired for when this constitution was founded should fully and comprehensively and to the satisfaction of everybody meet those demands, those needs actually. But unfortunately, there are those pockets which still need to be attended to. It's said that people died for this constitution. That is a system that we had to deal with at the time. But we should not lose hope and blame the constitution. It is the people who must implement the constitution that makes sure that it meets those requirements. As I said, some look at it subjectively and look at their own personal circumstances and say it did not work for me. There are those that would say it has worked for me. But by and large, there's kind of society that the constitution is aspiring for. We are on track to achieve it. We need to ensure that we fully implement it and achieve what we need to. There will always be resistance, obviously. Not everybody will agree. And now that brings me to the courts. They should play a meaningful role to ensure that the spirit and letter of the Constitution is implemented to benefit those aggrieved. Thank you.
Commissioner Malema was able to extract an answer out of you.
No, Commissioner, it's not fair. It's not fair to say that to me, with greatest respect to you. If I gave an answer that you did not like, maybe you should say so, then I can answer it.
No, you were more elaborate when you answered him than when you answered me.
Because he
That's-
gave specifics, you see, he said
yes.
this and that and that and that, and I indicated to you, it's such a general question that I need to deal with.
Yes, and no offense was meant by that.
Yeah, but, we-
But here's my second question.
yes,
It's in relation to the question that you were asked by Professor here
yes,
regarding the choice that women in particular are said to be able to make when they get into marriage. Now, I'm one person who believe that people, including women, are able to make their own choices, right, on issues of life, including a choice of a marriage or a type of marriage that they want to enter into, because that is a contract. Now, I want to hear your comment in relation to the principle that says agreements have got to be kept, the pacta sunt servanda principle. Do you think that it is a principle that can also be applied in relation to a marriage as a legal contract?
I think if we were to follow that, heavens might fall and say what's happening, because, Commissioner, you started by saying women are able to make choices. I fully support and agree. But here we are speaking of a special environment where that choice that they might make, it's not really a choice, because circumstances and the environment is such that she's forced into a particular corner just to agree. And if you come up with this commercial principle that agreements must be given effect to and must be binding, you'll be disadvantaging them all, because we don't have equal power relations in that kind of an arrangement. And this regulates family lives. It will be difficult in a family setting to say we have agreed on this is how we should go. I don't think it will apply. I don't support it in a marriage situation, because a contract of marriage, it's about status. Now, if you come up with that and say you sold away your status by agreeing to this agreement, definitely it won't work. I don't know how I can express it better than I'm saying. Thank you.
No, thank you. Or would you be comfortable if it's a situation that can be dealt with on a case-by-case basis? Is it a general statement that, is it correct as a general statement that women are not able to make choice in relation to issues of marriage? No. Or it's something that can be dealt with on a case-by-case basis?
We are not saying women, thank you. We are not saying women are not able to make choices. They do. And they have the capacity. What we are saying is certain types of situations are such that they are forced into certain decisions that under normal circumstances, they would not. Let me give you an example in our communities. Up to now, you still have a difficulty, and I experienced this as a practicing attorney, to say, look, if you decide to get married, you've got a choice to be in community of property or out of community of property. But the society and the spouse will say, hey, You know, I can't agree to that because my people, my parents or other people or my prospective husband's parents would say, "Man, you are not committed to that marriage." In Setswana, they say, "O tsena ka leoto le le one," so that o kgone go tswa. You enter only with one leg so that you can keep the other door open. And you'll find that the poor women are forced into the marriage, a marriage regime that they would not, had it been their own independent, uninhibited decision, they would not enter into. And they only realize later, when things become sour, that their proprietary rights were compromised by that kind of marriage relationship. But let me emphasize, women have the capacity and they do make meaningful and good decisions.
Thank you, CJ.
Follow up, CJ.
Yes.
Thank you very much, CJ. Thank you very much, JP. I think the discussion that we have just had with Mr. Mangiana is very interesting one. The Constitutional Court has dealt with how we should understand contracts in our modern day society. And there are judgments from the Supreme Court of Appeal which appear to be contradictory to what the Constitutional Court has said in terms of the role of a contract generally and how we can infuse constitutional principles. That debate it's there. Whether or not one agrees with the approach of the Constitutional Court, let's park that aside. Now, if we take the core contractual principles and we translate them into the contract of marriage, can we really say that a contract should be understood in the abstract terms in which a marriage contract should be understood in abstract terms in which a commercial agreement is generally understood? When one looks at how the Divorce Act and all the other acts provide certain remedies that assist the courts to come up with certain protections for women. Like, for instance, Section 7, Subsection 3 deals with redistribution. Section 9 of the Divorce Act deals with forfeiture of patrimonial benefits. So when one looks at those kind of remedies, can we really say that, yes, you contracted in community of property, let us just say the consequences of community of property must apply to you as strictly as one would understand in the contract sense? How can we deal with that aspect?
Yeah. Thank you, Professor. In that situation, obviously it will depend how the case is formulated by the parties. But I will be open to see and hear what has been happening in that kind of a relationship. And not strictly apply that law of contract, because here we are dealing with status of people who have been living together. And so it's possible to infuse the constitutional principles when you resolve that problem and consider everything. Strictly, when you come up with the contractual arrangement, say it's out of community of property, you get nothing. You've got situations where men bought everything in their names and nothing in the name of the husband or of the wife. And now how do you protect her? You have to go behind and look as to how these people live their lives, what contribution, and contribution can not only be monetary contribution, but support between spouses, and decide that issue, approaching it on that basis.
And that's why the redistribution remedy becomes important.
Yes.
Yes. Thank you very much,
One of the
CJ.
ones, yes.
Commissioner Lekhanyan.
Chief Justice, thank you so much. Good afternoon, JP.
Good afternoon, Commissioner.
Look, I'm going back to the question that was asked by the 4 commissioners, and it emanates from the dictum that you made here when you were given 30 minutes to present your vision. The English translation that the law must serve the people, it was said by yourself. And then honorable members, the commissioners are asking you question whether the South African Constitution in its current form is adequate, or whether there are deficiencies in the interpretation of the Constitution or statute in our judgments. So within that prism, or using that dictum which you have made here, the law must serve the people, are you convinced that in its current form, our Constitution is adequate? Or are there weaknesses in interpretation of statute by our courts? What is your view on that matter?
Yes.
Vis-a-vis, the law must serve the people.
Yes.
Yes.
Thank you, Commissioner. I would not rush to say the Constitution is insufficient. As lawyers, as the courts, I propose we must interpret the Constitution in such a way that it addresses all these problems that the society is facing. And that is the role that the Constitution should play. The provisions thereof are there to assist, and one can find a solution in that. I can't think of a situation where I would say it would not be catered for by the Constitution to the satisfaction. If you want to attain justice, if you want to attain redress, I would say it can play that role. It should be interpreted. The only problem is the interpretation in most of the time. The issue of the translation of judgments, which are important and run our daily lives, I was basing it on the fact that we should make provision for that. The technology has developed such that it can assist in doing that, rather than not doing anything. There should be a starting point, and as we move along, we might attain that. And that will then deal with most of the problems that people may doubt the Constitution. I like the idea that we have the Constitution, we have to make do and make what we can achieve with it as it stands.
Maybe as a follow-up, Chief Justice,
Yes.
Given that inequality and poverty perpetuate, against what you have said, that the law must serve the people, do you see the law serving the people?
Yeah, Commissioner.
Against the background of widening poverty and deepening inequality, is the law serving the people? That statement was made by yourself. The law must serve the people.
Must, yes. Every effort must be taken to ensure that the laws, that dream is attained. As I say, training and have a paradigm shift. When we look at disputes that we need to resolve, always keep the constitutional principles in mind and make sure that we decide the cases along that lines. There will be cases where there have been failures, but those mainly would have been due to failure to properly interpret the Constitution. So it's difficult to generalize, as I say, that it's not saving the people. That will be throwing the baby with the bathwater.
Okay. Let me ask the last question. It's not related to what I was asking.
Thank you.
The last question would be that in your presentation, you made a commitment to support the vision of the Chief Justice and to do your all best to ensure that the South African judiciary succeeds. If, for instance, the Chief Justice has outlined her priorities, what are the two priorities that she has outlined which you would choose, and in what way will you support those priorities? Just two of the priorities that she might have outlined.
Yes.
Which any two of those priorities that she might have outlined. You can choose any two and explain how you will support her in that regard. Thank you.
Yes, first, access to justice, I know it's close to her heart, and I'm equally supportive of access to justice, and whatever we do, and she calls us upon to do, one should work towards attaining that goal. Institutional independence of the judiciary is one of her priorities. So far, she has led us ably by arriving at where we are. What needs to be done is to take it forward. And I am available. All the other heads of court are available. And as I said, I need not be a Deputy Chief Justice to support her on that. We have always committed ourselves. And the independence of the judiciary is something which is very close to my heart. And that I'm definitely thinking that it has to be, it's an imperative. Thank you.
Chief Justice, the question is partly answered. The first part was that any two of the priorities. And the last part of it was, okay, what are the active or practical steps that you can take to demonstrate your support of those priorities?
Okay. We have already started to engage the executive. I'm part of a team that is negotiating with the executive. We're making proposals as to the engagement with the executive. What form should it take? What kind of institution do we want for the judiciary? The executive has got its own views on the kind of institution which differs from the concept that the judiciary has about a fully institutionally independent executive. So already we've got the two teams, technical teams from the Department of Justice and the OCJ working together to identify those issues that would need attention. I hope that they will also come up with the costing thereof and transferring some of the functions to the OCJ, which were retained in terms of the memorandum which was entered into by the OCJ and the Department of Justice when the proclamation was passed to establish the Office of the Chief Justice as a national department. Those should have devolved immediately, but they were retained and there was a memorandum of understanding. Now we want all those things to be devolved to the judiciary. So there would be practical steps over a period to ensure that they are there. Visiting the courts, making sure that everything is available to ensure that access to justice is attained. Those are the nitty-gritties that we will have to work on. We have identified them. The conference was there. As I indicated, there are those other issues. All of them, I indicated that they provide a template for our trajectory as to realize the aspirations of the judges at that conference, how we'll deal with them.
JP, thank you so much. Thank you, Chief Justice.
Thank you.
Yes, Chief.
Thank you very much. Good afternoon, JP.
Good afternoon, Commissioner.
As a follow-up to that question, in your career, let me put it this way. It is well nigh irrefutable that we are coming or we're part of patriarchal society. And in the light of that, there are some concerns that are being raised where men must serve under a woman, as it will be the case if you are taken in as DJP. DCJ, sorry. Now, as a follow-up, I wanted to ask you to clarify that in your career, did you serve? We hear you that you have no problem about that. But are you able to demonstrate that? Did you serve under a woman? Did you demonstrate that you will have no problem in serving under a woman? Your leader.
Yes. The starting point, Commissioner, would be say, I hereby, as I do, undertake to serve under a woman. I am committed to serve. I have said I've pledged my support to the Chief Justice and all women leaders, not only in the judiciary, but in the society as a whole. I come from a background of of serving in organizations, and we were led by women.
I'm surprised that you have not mentioned thus far, including to your responses to Commissioner Shabangumdawe, that the empowerment of women is actually one of your fervent passions. And the fact that there is a majority of women in your division is not because the division is merely because the division has created conducive conditions for women to prosper there. It's through your personal efforts. And the fact that there's a number of women who are in the judiciary across the country today through your personal efforts. Don't be so modest, JP.
Sorry, Chief Justice. I just want to.
And at Nadel, Chief Justice, we were led by women. I participated at the Law Societies of South Africa. There were committees which were led by women. I mean, one cannot divorce himself from that kind of situation. And I've never shown, and I challenge anyone, that I've had a problem being led by a woman. I've never had that.
I wanted to make a follow-up to Commissioner Soviet.
No, just one quick one on this one.
No, are you following up?
No, mine is
On this one, yeah.
on that.
Oh, all right.
So I'm happy to defer to Commissioner Malema.
No, mine is very simple that who's leading you now, right in front of your eyes now, in the judicial? And have you ever had a problem with that?
Not at all, and they are the capable women who are leading us.
Commissioner Ngaitu.
Sorry, JP, just on this point of your priorities coinciding or promoting those of the Chief Justice. These two proposals, one, the judicial road shows that you have in mind, and the translation of judgments into 11 official languages. Are those the priorities of the Chief Justice? Because I've never heard her talking about those things. Or are those your own ideas? You know, because I think the public would be astonished that the Deputy Chief Justice is planning road shows. The public is expecting judges to be in court, hearing cases and delivering judgments. They are utterly frustrated when that is not happening. So I don't even know when these road shows will be taking place, when the expectation out there is that our judges must be doing the job they're employed for. Quite apart from the concerns I have about where the money is for these ideas. I'm not even sure that they coincide with what the Chief Justice wants to do. The Chief Justice has told us what her priorities are. It's to strengthen judicial independence. It is to create greater capacity in the Constitutional Court to enable it to do its job. And is to create more resources across the board for the judges to do their job. And I just have difficulties with these parallel proposals that you currently have. So I don't know if you want to persist with those proposals or where exactly we stand with them.
In answering you,
May I do
Commissioner.
something unusual and interpose before the candidate answers, but just in relation to one part of your question, Commissioner Ngaitu, about the translation of languages into 11 official languages. It is one of my priorities, actually, to promote indigenous languages. And just earlier this week, a day ago, I spoke at the University of Western Cape about, promoting the use of our indigenous languages, not just all official languages in the courts. And that is not so far removed from what the candidate has said about the judgments, because that would filter down to judgments, which I fervently believe should be in all our official languages, because they all deserve the same opportunity under the sun. I've answered that part for you, JP.
I may
You are
add,
you are on your own about
yes,
the
I may
road
add,
shows.
Chief Justice, that when you were interviewed, I see the light
Sorry?
is on.
No, I just wanted to know, I understood that he was saying every judgment that's been given must be translated into 11 official languages. Now, I understand the point that if you are in the Eastern Cape, you can have a judgment in Xhosa and in English. And in the same as you, if you are in Limpopo, having the judgment in Pedi and in English. I've never understood this radical proposal in Sepedi, yes, well, I've called it Xhosa, yeah. But I've never understood this radical proposal of every judgment in every language. And I have a real problem about whether it's been costed so that we can take it seriously.
Chief Justice, if, yes.
Before
Chief
you
Justice, when you were interviewed by this commission,
JP,
Oh, sorry.
Tlaletsi, President Mulemela would like to add to the follow-up before you answer.
oh, I'm sorry, my apologies.
Yes, thank you, Chief Justice. No, it's a follow-up in relation to the second part about the road shows. JP Tlaletsi, you'll recall that when I posed the question to you about priorities, I said, what advice would you give to the Chief Justice in terms of what to prioritize, in terms, given the competing priorities? It's because my understanding is that if you are a deputy, not only do you follow the vision of the leader of the court, but you are also entitled to give advice. You should feel free to give advice, and if it is accepted, well and good. If it is not, then that's the end of the story. Is that the correct understanding?
Someone will say it's a leading question, but I concur, I accept. And President, I gave context to the roadshows. I said the administrative component of the judiciary should be the one that leads this process, supported by the judiciary. It's happening. I mean, I had students from high schools visiting me about last month, and we discussed all these problems. That's part of the roadshow. But on the issue of translation, the Chief Justice, when she was interviewed by this body, I think it's Professor Schlemmer, did put to her and commended her for having written a judgment in Isikos. And related to that, she was concerned that Africans is going to be lost because of the policy that English be court of record, language of record. And she indicated that she will be happy to see all other languages being accorded equal status. And the Chief Justice said, thank you, that is one of the issues that we will take forward as the judiciary. And I am saying, with the development of technology, it should be easy to digitally translate some of these judgments and keep a record thereof. It's not something that can be done immediately now, given the fact that we do not have our full institutional independence. We will get together once we have that and make a priority of what we would need to do instantly. Thank you.
Okay, who came first? Minister.
No, thank you very much. JP Tlaletsi, I'm picking up on the issue on translation and your comment that we can utilize technology to be able to interpret. We know that development of indigenous languages in technology is not yet there. If we look at, because you are likely to have different interpretation of the words from English to Xitsonga, for example, or Shangan, or even the Sepedi part of it, or Chivenda. Now, if we are to say one of the areas as part of us being able to implement in the courts, it means we are still going to wait for many, many years, because I don't think the independence, as you assume, is going to take long. JP Tlaletsi, we just need legislation and you'll have your full independence. I'm committed, President is committed to that. But if you are to say to us here, with many South Africans, and I appreciate the issue of using languages for judgments, because it's about accessibility of our courts to the people. Being able to speak their languages, language is the most powerful tool for transformation. But if we say in that doing, where I have a bit of a challenge, and I say this as a person who's quite familiar with technology and artificial intelligence, the development of those areas, especially on our indigenous languages, is not yet there. So we'll have to utilize the physical people who are going to the current system that is going while you are developing the language itself in terms of those platforms. So I think the issue of being cognizant around the cost implication, because I don't think even when we talk about the issue of the judiciary being independent, we've vetted the issue of the availability of resources within the state, within the country, for all of us, because we're going to take money from the same pot. So I thought I should just make that comment in terms of that area. Thank you.
Thank you, Minister, for that. As I said, it's a long-term goal that we ultimately need to see if we can strive, given the resources that we might get at the time, and the assistance that we might get from institutions that deal with technology and development of artificial intelligence. One other thing, Minister, that I was thinking also, it's if you could have some dedicated channel to mainstream the judgments, the cases in the Constitutional Court, and perhaps some important ones in the Supreme Court of Appeal, so that people can see, justice at work in the comfort of their homes. That can assist and not only be limited to YouTubes. We have the parliamentary channel. I think most people start to see what's happening in Parliament in a channel like that. I was just thinking also that as part of conscientizing people, reaching out to people, that you could have something like that. I know it will be costly, as some say. I don't know how costly it would be, but some things are imperative, they need to be done. And we can sacrifice a few of the things that we need to do that are not extremely necessary to attend to that. Thank you.
No, agreed. I know CJ and team are working on it, on the streaming of the Concord.
Commissioner Pule,
Thank you. It's a follow-up. Thank you.
You may ask your questions there.
Thank you, Chief Justice. Good afternoon, JP Tlaletsi.
Good afternoon, Commissioner.
JP, in the course of this afternoon, you've repeatedly used the term full institutional independence for the judiciary. And earlier when you presented your vision, you lamented the fact that the judiciary is accountable to National Treasury for its budget and subject to budget cuts by National Treasury. Now, my question is really in two parts. The first is, do you believe that full institutional independence is possible? And if so, what checks and balances do you propose in relation to the judiciary's handling of public funds?
Yes. Well, thank you, Commissioner. I would call it full institutional independence, in the sense that the judiciary will be running its own affairs. The judiciary will be part of the arms of state that get money from the treasury. And then there should be systems in place within the judiciary, how to employ those finances. There has to be, and I did indicate that, an urgent matter that you may have to consider. how are we going to account with the kind of monies, the monies that you are going to get? Currently, we have the Secretary General going to the Portfolio Committee to make an explanation there. But this thing has been a sticking point because the parliamentarians go beyond at times, and rightly so because it involves money, to ask about the activities of the judiciary. And it created problems, as if now the judiciary is accounting to the Portfolio Committee, to the politicians, something that some members of the society also frowned upon it. But there has to be a structure. Let's say if we take the current model that we are thinking about, that you are going to have a judicial council and an advisory body. That council should have a system of accounting to the treasury on the appropriation that we would have received. And it should not only be enough only for what we call Judiciary Day and invite Portfolio Committee members to listen to what we say and produce reports. We want to see full accountability and make sure that everybody understands that we are functioning within the parameters of the state as an independent arm of state. Issues of employees within the judiciary, those are the issues that will need to be taken into. I don't think personally it would make sense have our support staff reporting to public service, to the Department of Public Service. I mean, they have their own priorities. And that creates problems now between the judges and the employees. At the moment, I know you know this very well, Commissioner, that they fall under the ministry and their loyalty in terms of the prescripts of the public service and the act. Loyalty first is the minister. And we are being consulted. And this has been a problem. But I assure you, we have to have a meaningful way of accounting to as an arm of state. The Judicial Council and the CEO, if we have some person like that, or whatever we call ASG, the Secretary General, should be the one who present that. I would not want to see a situation where the Chief Justice go to this organization, to the arms of state and account to them and being asked questions. Thank you.
But in your scheme, JP, you retain National Treasury's role as the custodian of the budget.
Definitely, that is the entry point of all the monies, and this is where we are going to get the monies from. And even if we were to get funds and whatever from other sources, we have to disclose them to the Treasury, and the Treasury must make a record of those to ensure that there is transparency. Thank you.
Thank you, JP. Now, just in relation to the answers you gave Commissioner Shabangu Ndawe earlier around the role of women, and I take note of the CJ's remarks about the role you've played in advancing women in your division. I was making a careful note of your answers around what is needed to advance women in the legal profession. And I'm a bit concerned about your direction, and I'll tell you why. You raised 5 issues. You say there must be better education at universities. You said once they're in a profession, women must be trained to move forward. You said that women must be given opportunities within the profession. You said that they must be given opportunities to act. And you said that conditions should be made easier in order to accommodate women. The difficulty with all 5 arguments or points that you raise is that it places the spotlight on women and seems to assume an inadequacy in the woman. What you don't touch on is the systemic barriers to the advancement of women.
Yes.
Now, I just wanted to find out, to your mind, what are those systemic barriers to the advancement of women in the profession?
Yes. Actually, for me to catalog those issues was relating to systemic barriers that women face. I did indicate that in addition to their, for example, practicing as lawyers, they do have other challenges that they have to face because they are women and they are running families and all that. So we have to make sure that we accommodate them. There's provision for that. And within the structures of the profession, there should not be any barriers that makes it impossible for them to advance. Not that they must get special attention. They are fully aware, they are fully adequate, and you have seen the results that they are doing well. And even when they appear in our course, we'll see that they put a lot of weight and they influence most of our decisions. So I was just thinking of those things that one would find in the profession that would make it impossible for them to stay on and to advance their careers within the profession.
Do you believe that women lawyers and or women judges operate in an environment that's inherently hostile to them?
It depends where one finds himself or herself. If I take the let's say advocacy, the kind of work that is dished out to practitioners, it's not always that you find that women benefit from that private and business work. Mostly, they will get work from the state attorney. That is from where I've realized where I preside. Maybe some RAF matters, a few, but mostly the briefing patterns makes the environment hostile.
So JP Tlaletsi, that's precisely what I'm driving at. Do you know why that's the case? Why aren't women getting the commercial work? Why are women forced to depend on state attorney work and RAF
Yes.
work?
I think it's a question of acceptability by those who are already there. There's some of the excuses that they would give it, say, my client wants me to do this, this is the instruction from the client, which I believe, I mean, you have to advise your client as to what is the policy of the profession and how you should also conduct your practice. So, but the environment at times, it's such that it makes it impossible for them to continue.
And speaking of a hostile environment, do you believe sexual harassment within the judiciary is an issue?
I wouldn't say it's an issue that I have identified as a problem. I am aware of an instance that has gone public with those allegations, but I am not aware of, or I could say it is a problem as such. But one should not rest on saying it's not a problem, because there could be those that we are not even aware of. So having a anti-sexual harassment policy will assist to open up and make us aware that there is this problem. So they might be kept secret. There might be those instances. It might be difficult to know that they exist, they are happening. And obviously if they are happening, then they will get reported. If I'm a head of court and I come across that problem, I will take it up immediately.
Chief Justice, it's just the last follow-up and then I'm done. Just in relation to the so-called anti-sexual harassment policy, I just want to understand, firstly, you know, you've been asked exhaustively today how you align with the priorities of the Chief Justice. What you've just indicated now, do you believe that aligns with the priorities of the Chief Justice on sexual harassment? That's the first question. The second one on the so-called anti-sexual harassment policy, have you considered the policy and do you believe it addresses all the specific characteristics of the judiciary which makes sexual harassment an issue within the judiciary?
Yes. I aligned with the policy, the priority of the Chief Justice. This comes a long way. I was part of the heads of court when it started, and There was an attempt to have one, but it was held back and said it needs to be formally and professionally be prepared so that it can cover everything. We have looked at it. I personally looked at it, and I do not have a problem with it. There were only a minor issue, I think, that I looked at, which I had requested that the committee should look into, or the preparatory committee, where it extends over to the employees. It is a judiciary policy, but currently as we stand, we still have the employees who are going to be covered by it, which might conflict with the policies that they have in the public service. So those, and we do not know whether those policies or their actually policy do cater for what is already contained, but it was just to compare. But within the judiciary, I know there were other issues that were raised, but I do not have a problem there with. And I don't have a problem. And I fully support it, I must say.
Sorry, Chief
Follow up,
Justice,
CJ.
I need to really follow up on this one. So, the difficulty, sorry JP, I know you are drinking water there. I'm not interrupting your need to drink water. But I think there may be a misunderstanding of what your answer is on the sexual harassment question. Remember that the question was, do you believe that sexual harassment is an issue in the judiciary? And then you said, I wouldn't say it is an issue. Now, I have a real problem with that answer, and I believe that you may have miscommunicated. Everyone sitting here interviewing you believes that sexual harassment is an issue in the judiciary, and that it must be uprooted, and that it is pervasive, but it is unreported, and it's unidentified because victims are afraid to come out because the structure of the judiciary is patriarchal.
Yes.
That's what everybody here believes. You're the only one in this room who believes it's not an issue.
Well,
Can you just clarify your answer on that issue so that we don't come out with a wrong impression?
yeah, I indicated that.
Perhaps before you answer that question, JP, let me add to Commissioner Ngukaitobi's question.
Yes.
Your division, well, the draft sexual harassment policy doing the rounds received overwhelming support from the entire judiciary, bar one division, your division. Yes, your division is one of the few among us who came up with useful substantive issues for further considerations, which is what we are busy with now. But then its final word was that there actually is no need for the policy because we have the Code of Judicial Conduct, which is adequate to deal with these issues. And of course, it was a joint report of the division, not written by you, but by a senior woman judge in your division. But one assumes that you were part of that view. And I want to, as you answer Commissioner Ngukaitobi's follow-up question, to assure me, to assure us and everybody else concerned,
Yes.
that you really support this document and believe that there is need for it.
Definitely, Chief Justice, I support, and I did indicate, and I do also say, I support it. And as I say, it's just a question of having to compare with the public service, how it extends to the administrative staff. On whether it is an issue, my answer is based on the fact that I cannot say it's not there. It could be there, but it's not in the open. But if I were to come across any of such an incident, I am bound to immediately raise it and not allow it to lie there and not be attended to. Up to now, I have never come across an issue which I have known about sexual harassment, that I would have had to disclose or be even a complainant about it. But if the scourge is there, I accept it, but I have not come across a case like that. If it exists, obviously it should be an issue, but the problem is the incidents that I was not aware of. And if the members of the House say it is there, it means then there will have to be further investigations to make sure that it's rooted out and not only allow the victims to come up and create an environment that it is being addressed. Thank you.
Commissioner Baloyi?
Follow up, CJ.
Thank you. Good afternoon, JP. Yes, JP, this, what you've just said now, that in fact, I think a few comments earlier even, that you're not aware that it is a problem, sexual harassment in the judiciary, is concerning if it suggests, and that's what it seems to suggest, that there is in fact no discussion within the judiciary about what has been identified, but for your division, that has been identified as a problem in the judiciary. I mean, as Commissioner Ngugaitobi says, that everyone in this room knows that there is a concern about sexual harassment in the judiciary and that it is pervasive or it is a real problem. And if you say, well, I'm not aware of it, it's worrying because because then it suggests conversations are not happening in the judiciary. They may be happening in silos, if they are happening, but if you are not aware of it and you're not part of those conversations, then it's a completely different worry that we should have.
Yes.
Is it a fair reflection that there's no conversation in the judiciary about this?
Commissioner, thank you, Commissioner. I would say in my division, we haven't had such a problem that I had to deal with, especially in the High Court. I do not recall being party to a conversation, say at national level, that you have this catch and that it need to be attended to. We all accept that if it is there, and we know it's difficult for it to come out. But I personally would say I have not had intimate discussions relating to it that much, my recollection.
Can I just,
Thank you, CJ.
just a follow-up on this
Minister?
one? JP Tlaletsi, what
Yes,
is your understanding of why the CJ, as one of the things that she has put as a priority, I think in every meeting that I meet her, for example, I know there's no way that meeting will finish without her talking about the gender desk and the issue of sexual harassment policy. I know for a fact. Actually, I panic when I go to her if I don't have answers around that area of work. Now, with your response, what is your understanding of her being so much putting pressure on this issue that led to yourself as part of the heads of courts that sits with the CJ as the leadership of the judiciary, not being able to pick up this issue as something that you must open conversation in your division?
Yes. In the first place, there was no policy at all. If there was a complaint like that, it would go the normal route of the JP or directly to the JSC. But that lack of policy being in place did not necessarily mean that it is not there. So one of the objectives of the policy, I think, is to make, for everybody within the judiciary to be aware and not to sit with problems. They should come up. But what I was saying is that policy has certain definitions of things that people would not have thought that they would amount to sexual harassment. But being part of the society in South Africa, I mean, you would get a situation where there is sexual harassment. But I was merely saying I've never put my finger on any of such conduct within the judiciary where I serve. Thank you.
No, thank you very much, Chief Justice. JP,
Ma'am.
it's not about you coming across sexual harassment. What we want to know, what is your conviction, your views about it? You seem to come across as someone who's holding back his views, and that does not assist us seated here. So up until now, you've left us confused on a number of issues. So please, explain yourself. What are your views about sexual harassment in the work environment?
Commissioner, I abhor it. I don't like it. I dislike it. Wherever I see it, I will report it and I will deal with it. It's something that I will never support personally or even in my professional capacity. If I created any impression that maybe I will tolerate it, I would never, definitely. Thank you.
Commissioner San?
Thank you very much, CJ. JP, I'm also going to ask this by way of follow-up related to the sexual harassment policy, but I'm going to craft it a little bit differently. Look, JP, the Deputy Chief Justice plays an important role in supporting the Chief Justice, not only in terms of judicial leadership, but also helping drive institutional reform. And one of the CJ's stated priorities, and I think Minister also mentioned it now, is the finalization and the implementation of a clear and credible sexual harassment policy for the entirety of the judiciary. So the question is, what are your views on the role that policy should play in preventing and addressing sexual harassment in the judiciary? And how would you see yourself supporting the Chief Justice in ensuring that this policy becomes an effective and enforceable tool for change? Thank you.
Thank you. Already with the current process, everybody in the judiciary is aware that there's a process of having this policy finalized and to be put in place. Once it is in place, it is the responsibility of every judge to start with, irrespective of the position, whether as leadership position or not, to ensure that this policy is implemented. It is well understood, it is known. If I am appointed and it is one of the matters that specifically the Chief Justice assigned to me, I will run with that still and make sure that well understood, it's being implemented, and there's no case that goes unattended to and unpunished. Even if I'm not the Deputy Chief Justice, I still commit myself that I will deal with that issue of sexual harassment in whatever form. The good thing is the policy itself, once finalized, it will explain how sexual harassment manifests itself. And that's why victims do not readily come out to report this kind of harassment. And it will be a conduct and a standard that each judicial officer should live by for all levels of the judiciary, from the judges, president, let's say, from the Constitutional Court up to the lowest court in the magistracy, including the land claims courts.
Commissioner Malem?
Thank you. I didn't want to get involved, but I realize I must just try and help the situation. Is there a sexual harassment problem at workplaces in South Africa?
Is that the question?
Yes, I'm
Well,
asking.
Yes. From my experience, starting from the labor court, there has been that problem that has been identified.
So judiciary is a workplace.
I don't know, do we need a dialogue, Chief Justice?
Don't do that, because we're trying to find your view on this matter. I'm not engaged in a dialogue with you, JP. I'm trying to arrive at a certain point. Why? Because you are making it difficult to make up our mind in relation to your thinking on this matter. That's why I'm coming up with a different approach. I asked, is there a problem of sexual harassment in society? You said yes.
Yes.
Is judiciary not a working place.
It is.
Therefore, it means there will be a problem of sexual harassment in the judiciary because there is generally a problem of sexual harassment in society.
Yes.
Now that you came before us to apply for a position where you are going to support the Chief Justice and you are confessing that you didn't know that there is a problem of sexual harassment in the judiciary, now you know.
What I'm saying, Commissioner, is the actual cases in my workplace, I have not come across that. But I do not rule out that they are there. I'm saying without a policy, it will be difficult to get to know about these cases. Once there is a policy in place, it will encourage everybody to make it known so that we have this scourge and then address it immediately.
No, JP, you are applying to go and assist the CJ. Assist her on what? Because you don't know what are the issues there, what are the problems. I'm saying, with all of everybody's input now, not your experience, where you work and all of that, now at a national level, with national consciousness that is given to you now, out of this input, do you accept that there is a sexual harassment problem in judiciary in the same way there is a problem of sexual harassment in society? You might have come here not aware, but with everybody's input now, do you now accept that it looks like there is a problem the judiciary is dealing with? You were not aware of it, you are now aware of it. But it makes it problematic for me to want to go and help the CJ on matters that you don't know. Help her on what? Because you don't know there is a problem she's dealing with.
Yes.
That's why she's trying to expedite the issue of sexual harassment policy, which you are aware of. And when it became an issue, a judge with interest in leadership position would have inquired as to what necessitates such a policy. Because we've been operating here, there was no policy. Why now? Because you have got interest in leadership position. Being Deputy Chief Justice is a leadership role and is to help the Chief Justice, and you are going to help her on issues that you are not aware. What are the issues? Now you know, you do accept that there is a problem of sexual harassment in the judiciary with all inputs given here.
I have been assured that there is that problem, and I do accept that there is that problem. What I was trying to put forward was that I personally have not come across a specific case that I had to deal with, but if the scourge is there, I do accept.
CJ, I personally never came across a case of racism, but I know there is racism.
Are there any further questions for the candidates, colleagues? Ingos.
Thank you, CJ. Good afternoon again, JP.
One more time, good afternoon, Commissioner.
Can I be protected from my left? Sorry, Chair. South Africa is composed of different and diverse nations with different cultural norms and values, as you know.
I just missed the last word, different.
Norms and cultural norms and values.
Yes.
As you know. In fact, it is a mirror of United Nations, but the Constitutional Court, therefore, is a mirror of International Court of Justice, but with a difference, because this ICJ of ours is binding on all of us in South Africa. No one can ever defy it. Now, there are two legal systems in our country. The Roman-Dutch legal system and as well as the indigenous cultural, customary legal system on the other hand, and the need for both to be treated equally, as you know, in terms of the Constitution. And now, are you going to be able to deal with this issue if you are accepted and taken as a Deputy Chief Justice in dispensing justice, assuming that there may be, of course, a case involving parties, either the Roman Dash on the other hand, or customary law on the other hand. And how are you going to be able to deal with that? In other words, what I'm trying to test from you, I know what you're capable of, but I would like to know more whether you are capable of handling the complex issues that are within the customary indigenous legal system.
If I may understand, it being a case that has elements of customary law or indigenous system and so-called civil law. I just wanted to make sure I understand the question, Commissioner.
Oh, thank you. Through you, Chief Justice. Yes. All I want to know is to whether you are sensitive or capable of understanding the dynamics involved in terms of promoting this dual legal system. The Roman Dash system on the other hand, as well as on the other hand, the customary one, indigenous law. Right. In terms of the Constitution, I think you know that they must be treated equally, but both are subject to the Constitution of the country. That's all I want to test from you, whether you understand those dynamics, and if so, will you be able then to dispense justice? But I want you to concentrate on the other side, not the Roman Dash legal side, on the customary side. That's what I wanted to test your knowledge there.
Yes. No, Commissioner, definitely our society and the majority come from the traditional, we can call them the traditional society, and they have been regulating their lives in terms of the traditional norms, customary rules and beliefs. And obviously, if I have a case like that, I will be in a position to identify the actual problem and look at the parties, and surely if they subscribe to that, make sure that it assists in resolving the problem. If you consider one of the judgments that I wrote, Kivis Kroon, Country Estate versus More Lady, it was an employee who was dismissed. She was a chef, only because she had to undergo a process of twasa. And the employer said, look, whatever you are going through is not an illness to us. You don't comply, and she was dismissed. And I managed, when I dealt with the case, to identify the beliefs that she had and the system, cultural, traditional beliefs that she went through and that she was going through, and found that dismissal to have been substantially and procedurally unfair, and ordered her to be reinstated. The Supreme Court of Appeal agreed with me and endorsed that judgment. So they have to play a role. And actually, that kind of system, particularly when you come to these areas where it applies, it has built in it a form of mediation, and it quickly resolves problems that exist within the society, more so that people subscribe and believe in that system. You actually do not need someone sophisticated, educated in this kind of other law to be able to practice that. On its own, it can be a self-standing system that regulate the lives of the society in that area.
Is it to you, CJ? Incidental to that answer, what's your view on the role of traditional courts in dispensing justice in South Africa?
To buttress what I've said, they play a very good role a very meaningful role, and they are part of our court system. And we should encourage dispute that can be resolved at that level, to be in that fora, to be resolved at that level. Unfortunately, because of the subscription to the norms and traditional values, people subscribe to them and they do not create a problem at all. And people continue with their lives.
Thank you, CJ.
Thank you.
Thank you, CJ. Good evening,
Good evening.
JP Tlaletsi.
That time already. Thank you, Commissioner.
Mine flows from a point that you made earlier when you were making a presentation with regards to the need to relax rules as part of your plan to ensure expeditious conclusion of matters, but also to ensure access to justice. The decolonization of the law project, which remains a stubborn elephant in the room, despite debates at various levels, to really deal with this question of decolonization of the law, there seems to be lack of political will, lack of appetite, and such that the project has not really gained much traction. What would be your role as the DCJ in ensuring that this project gains that momentum and that we begin to make meaningful inroads in ensuring that we dismantle the colonial legal system? Thank you.
Yes. Thank you, Commissioner. I personally believe that there are certain of these systems which may not necessarily be suited to our conditions. And those that do not advance the relations between citizens can be done away with. If it becomes one of the assignments given to me by the Chief Justice, I will get the stakeholders and start a debate and take it further as to how we can embark on the process of decolonization of the law. It's a welcome project that I think we need to embark upon.
Thank you, CJ.
It does not appear that there are any further questions for you, Judge President, so we have reached the end of the proceedings. Thank you for accepting the President's nomination for this vacancy. We appreciate it. I know you were not particularly keen to accept it, but then you made yourself available. And thank you for bearing with us. Is there anything you want to raise with us before I release you?
Well, to thank the commissioners and the commission for the discussions that we had, and I think they are very fruitful and they will take the judiciary forward. And I enjoyed them, I must say. The length of time we spent together in here can only be something that we all learn from it. And once again, thank you for this opportunity, for this invitation. Convey my appreciation also if the result does not come my way, that I appreciate the confidence that the President has had in me by making me part of this process to enable him to decide who would be the Deputy Chief Justice. As I said, I don't feel that I am entitled to it. There are other people who could be in a position to be given this opportunity. We are equally, differently empowered for this position. I thank you very much.
Thank you, JP. Go. That's the end of our day, colleagues. Just spoke, how did we do it? That's magnificent, all right.
Did we catch up with Chai?
We did, we did. Okay, we'll meet tomorrow at 9 a.m., colleagues. Thank you.
Give us a great afternoon.